Welcome to this edition of Thought to Action, presented by the Herb London Center for Policy Research. I'm Chris Cordani. I'm hosting this episode. If you enjoy our content, don't forget to hit that like button. Also, comment, share, and subscribe. That's the big red button when you're talking about YouTube. And on Rumble, it's the other colored one. To enjoy sneak previews of our videos, exclusive content, and more special programming in the works, join our Patreon page, patreon.com/thought-to-action. As a subscriber, you'll also have access to our Ask Us Anything sessions, where we at the London Center answer your questions. You can follow us on Facebook, Twitter, LinkedIn, Getter, and our website, londoncenter.org, and check out our Teespring store. This is a very special edition of Thought to Action. The recent leak of a potential majority decision to overturn the 1973 Roe v. Wade Supreme Court decision sparked quite a bit of debate over how justices need to approach the Constitution, whether to adhere to constitutional originality or a more activist-based approach. The next question is, do we need, and when do we need, or is the time now for an amendment to make sure that there are 9 justices in the Supreme Court, so a president or any administration or a party which has control of both Congress and the presidency does not pack the court? Our panel today, London Center for Policy Research President Tony Shaffer, Lieutenant Colonel retired. Former United States Attorney General Ed Meese is with us today. We also have London Center for Policy Research Distinguished Fellow Navy Captain retired Pete O'Brien. Ramon Buehler, Director of the Keep 9 Coalition, and former Tennessee Attorney General Paul Summers, Chairman of the Keep 9 Coalition. Gentlemen, thank you for joining us. Supreme Court Justice Neil Gorsuch once wrote, quote, "Suppose originalism does lead to a result you happen to dislike in this or that case. So what? The judicial power of Article 3 of the Constitution isn't a promise of all good things." Unquote. This comes to a head over the recent controversy over a possible overturning of Roe versus Wade. Gentlemen, let's discuss that first, and the concept of constitutional originality, especially in this case.
So I'll start off. Again, Attorney General Meese, Mr. Attorney General Summers, Ramon, Pete, thank you all for being here today. This is an important issue to walk through. So as I often tell people, while I'm not a lawyer, I did play one in front of the Iowa Supreme Court. To good effect, by the way, since we beat Northwestern University in '86 there in our mock trial championship. With all kidding aside, I'm one of those who has studied this as a layman. And the effects of this potentially will literally rechange the legislative landscape by the fact you already see legislation already going in directions all across the United States. And I don't think it's a bad thing, because if the Alito draft is essentially going to be the decision of the court, it pushes the entire issue back down to the states, which I would argue that is the correct decision. I believe, again, as a layman, I'll leave it to the experts to lay it out. Roe was wrongly decided, and let me say this based on my interpretation. Again, I'm not the expert, but I think this may be correct. This could have gone the other way. You could use the 14th Amendment to essentially say all life begins at conception. Therefore, we must ban all abortions. So they could have gone the other way with it just as easily, because it's interpreting a right or an issue that's not been decided by the Constitution or by any legislative or legal framework. So that's my going in take on this. It's basically saying the way it was decided was not correct. It could have just as easy, or could just as easy go the other way, where they use the same thinking to ban, to saying that life begins at a certain point. Therefore, we interpret as the court of the land that a fetus has the right to exist, and therefore ban all abortions. I don't know if they thought about it in those terms, but that's why I'm looking at it. And then obviously I'd like to talk about kind of the reaction to all this to include, since we've first contemplated doing this, we've seen protesters showing up in front of the homes of all these conservative Supreme Court justices and attempting to intimidate their thinking, which, by the way, as I understand it, is against federal law. But who am I to judge? So with that said, Attorney General Meese, Ed, thank you for being here. If you could just roll it over to you next to have your thoughts on this.
Okay. I would disagree in part with you, Tony.
Yes, sir.
would not be just as easy to go the other way than this draft opinion does, because if you go back to the whole idea of the Constitution, it was to be a constitution of limited government, and only certain types of things were ceded to the federal government to deal with. And certainly this was one of those that was left deliberately to the states. The whole idea was that the federal government would only deal with those things that had to do with national and international things, such as defense of the country, or laws such as that, and something that really dealt with individuals, something that had to do with day-to-day activities of people, that was by design left to the states, as the 10th Amendment says, that those matters not deliberately set forth in the Constitution are left to the people or to the states. And so this goes back to the whole idea of the original meaning of the Constitution, and that should be the basis for the interpretation. So in two ways, the decision in 1973 of Roe against Wade violated basic principles of interpretation. First, it was not in the Constitution specifically or even by inference. And secondly, it had to do with things that were always left into the states to deal with the particular items. And I would comment particularly, you're absolutely correct on one thing. It is a violence with the kind of picketing and demonstrations in the neighborhoods of the constitutional members of the court is a violation of federal law. There's a specific law that deals with this subject, and it even mentions the houses or the living quarters of the judges as one of the places that is protected by that law.
I agree with General Meese. Our forefathers not only were smart, they were clairvoyant. They created two separate branches of government, which were purely political. The third branch of government, after nomination and confirmation, is supposed to be and is independent. The judicial branch of government, specifically the Supreme Court in our context, is independent, operates and judges what the Constitution says, operates under the rule of law, that is, that all men and women are created equal and endowed with certain unalienable rights of life, liberty, and pursuit of happiness. And most importantly, they are a checks and balances on abuse of power by the other two branches. Now, we have to have an independent court system that is not subject to politics or policies or basically what is popular at that time. They read the Constitution and interpret the Constitution as they see fit. There is nothing unusual about the Supreme Court overruling itself and saying in the previous case, we just got it wrong. I cite you scores of cases, but most importantly, one that we all remember, and that is Plessy versus Ferguson in the 1800s, which basically said that separate but equal is okay. Then in 1954, I think it was, we came along with Brown versus Board of Education, which said that separate but equal is not correct. It needs to be equal. They overruled Plessy versus Ferguson. There's nothing wrong with that. There's nothing irregular about that. And there are scores of cases where the Supreme Court has overruled itself. Now, all that said is that the Keep 9 Amendment is an amendment that creates a firewall against a political party that is in charge of both the executive branch and the legislative branch from increasing or decreasing, but primarily increasing the number of justices just for popular political preference at that time. What would happen, gentlemen, what would happen if the Supreme Court, which could be the number could be changed just by an act of Congress that's signed by the president. There's nothing in the Constitution that prohibits increasing or decreasing. But what would happen if one political party increased the number of justices and then another political party gets in power? They're going to do the same thing. The next thing you know, some grandchild is going to ask her granddaddy on Thanksgiving Day, "Granddaddy, why do we have 31 members on the United States Supreme Court?" That's not the independence that we need. We need to keep it. It is a crown jewel, and the Keep 9 Amendment is a firewall against court packing.
Well, you could call it the Supreme Court Brigade and turn it into a Monty Python skit, which I think would be pretty funny, but probably pretty ineffective. So, Ramon, do you want to jump in and kind of follow? Because I agree that, the Constitution, I think we could all agree on the constitutional issues here. And it seems to me that needs to be highlighted to the American people. By the way, the left seems to be completely watering down everything we're talking about here by lying about what this all means. So I'm going to pick that up.
Sure. We have the Plessy versus Ferguson decision was overturned after a little bit more than 50 years. It's been just about 50 years since Roe versus Wade. As is often the case, the media is looking at the wrong target, and they have a reason for doing that. The left's long-term goal is to pack the court. And it's not just that they want to overturn this decision. It's that the left wants what leftists all over the world always want, which is absolute power. And they cannot achieve absolute power in our system because of the constitutional checks and balances we have, unless they control Congress, the White House, and the courts. And so they can't achieve much of their long-term agenda without control of the court, which means essentially without packing the court. And the really terrifying thing that nobody focuses on right now is there are now 200 members of Congress who support the Keep 9 Amendment, which simply says the Supreme Court of the United States shall be composed of 9 justices. Polling shows that by a 3-1 margin, voters would back that amendment. And even a majority of Democratic voters would support an amendment that says the Supreme Court is 9 justices. And yet, here's the frightening thing, not a single Democratic member of Congress in this Congress has yet chosen to support the Keep 9 Amendment. Now, many of them say they're against court packing, but someone who says they're against court packing but won't support an amendment to make sure it never happens may not be telling voters the whole story. And this amendment was first introduced by a Democrat in 2020. It was first championed by a bipartisan group of attorneys general, a majority of whom were Democrats. This amendment is bipartisan in its origins and bipartisan in its support. And yet in the polarized Washington scene, it has become, unfortunately, a partisan issue, and that is because too many politicians in Washington want the power to turn the court into a puppet of Congress, and that is the central issue, and we have to let the American people know about that.
Right. Pete, you want to pick it up and kind of see what you think regarding the circling of all this together?
Well, I know considerably less about this than any of the rest of you gentlemen. I would throw out though one point, and it really kind of reduces to, if you will, a philosophical argument. It's the use of words and what the word rights meant to the founding fathers, and what it meant was far different from the way the word is used today. It meant a claim that you the individual had to an ability to act that preceded the government. It came from, if you want to paint it that way, nature, but it really came from God, and it was something that existed apart from anything that the government was doing. You had that right. That right was innate, and what the government did was in the form of the Bill of Rights and other elements of the Constitution was it protected your rights from the ability of somebody else to act, whether it was somebody else in the federal government or the state government, but it protected your rights. The rights did not come from the state; they already existed. And what we've seen today is a very deliberate conflation of rights and needs and privileges into under a single word rights, but they aren't rights, and so you wind up with I think a very strange discussion going on in which what we're arguing about obviously in many cases are not rights, and yet we've sort of lost that argument. I think part of this whole idea of getting back to a focus on the original meaning, which is sort of what the 9 justice issue really talks to, is to essentially reclaim those words.
Yeah.
Back to what Paul was saying. You're right. Without a Keep 9 amendment now, it could be argued your grandkids and other kids might one day be fighting for the Keep 35 amendment. That's not going to be fun either. But going back to what Ramon said about government control, gentlemen, what should go unnoticed is from the politicians and live document activists we have who want to bend the Constitution's interpretation to their own will, also tend to constantly attack the Bill of Rights. We talked about the 10th Amendment being ignored by Roe versus Wade's decision. Federal legislators tried hard, especially in recent years, to circumvent the Second Amendment, First Amendment, and the Fourth Amendment under the guise of protection and public safety, which we all know was a fancy way to say, Ramon, as you put it, government control. This presents, once again, the great need for justices to adhere to constitutional originality. Attorney General Meese, talk about how we can try to educate younger people and bring the concept of constitutional originality to a more popular, or I should say, a more a real litmus test for future justices. It's no matter who is controlling the Senate or the presidency.
Well, I think one of the things is to follow strictly the rule of what was intended by the people who wrote the Constitution and its different provisions. And that's pretty easily determined. And we've had very little trouble staying with the original Constitution until fairly recently, when we've had a lot of people who would try to avoid what the Constitution actually says and substitute their particular biases, their policy preferences, or their own ideas for what the Constitution says. So it's a matter, it's very similar really to how you would interpret a contract. When you have a contract, say you will sell someone something for $1,000, and then you say, well, $1,000, actually $1,000 today is only worth maybe $900 because of inflation. So we'll only pay you $900. Nobody would go for that deal. And the Constitution is the same way. We should not go for a deal which changes the fundamental meaning of particular words. And so I think this idea of going back to original understanding of what the Constitution is something that now it looks like probably at least 5, possibly 6 members of the court are firmly committed to, and that's a great improvement, frankly, than those who passed those who promulgated Roe against Wade, where they were willing to change the meaning of the Constitution in order to reach their policy.
I'd like to say something about young people, because in the Keep 9 effort, we have 2 groups of young people who usually don't agree on anything. We have a group of very conservative young people who are supporting the amendment, calling elected officials around the country. But we also have a very unique group called Progressives for Keep 9. And most of these young people are fans of Bernie Sanders. And they are also big supporters of the Keep 9 amendment. And as we talk to them, we were trying to understand what their motivation was. And the thing that these 2 groups of young people have in common are they don't trust politicians. And as one of them said, a young Hispanic fellow from Chicago, he said, if you're pulled over by the police for some offense, do you want to go to an independent judge, or do you want to go before a member of the city council to have your case evaluated? And so they understand in a general way the power of rule of law. and the danger of rule by whim of politicians. And I think this common theme that politicians are not worthy of our complete trust, they need to be held accountable, their powers need to be limited. I think it's a theme that extends across the ideological spectrum in some ways. And that one of the reasons why we may eventually get this Keep 9 Amendment enacted and why it has such broad support in the public is because it doesn't depend on whether you are a liberal or a conservative or a progressive. You care about making sure that politicians don't control the courts.
To that point, Ramon, I think it seems to me that our system, and Ed, well, I'm going to refer to an event which I know happened in Old Town Alexandria, where in the old days, President Reagan would at least have Tip O'Neill be willing to meet and talk about issues that related to how do we protect the American people versus their political parties. And some of you know, and I'm using this as a modern reference, my friend Dennis Kucinich asked me to advise his friend Tulsi Gabbard on national security issues. And our mutual friend Ed of course, Jim Woolsey and I sat down and did that because our belief, Ed's belief, I think Dennis's belief, Ambassador Woolsey's belief, my belief is that we should agree on some things, no matter what our party is, and protecting the Constitution, protecting the sanctity of the legal system, protecting national security should be those things. And that's what I find frustrating is that those voices on both sides of the political aisle are being shouted down by a group of folks who essentially have signed up, I'm just going to say it, to Marxist ideology, which has no place in our political system. So that may be a bit harsh, but that's kind of the way I'm seeing it right now. So,
may I expand on one of the other historical issues? The Supreme Court in 1789, when the Constitution was ratified, consisted of 6 justices. Since that time, reduced to 9. It has been 9 ever since for the last 153 years, and the system has worked extremely well. Not flawless, not always popular, but extremely well and independent. In 1937, when FDR was in absolute power, his party was in absolute power, he attempted to increase the number of justices by 6, as I recall. He failed miserably, even though he had all the votes in the Congress. The reason was that they realized in 1937 that increasing the court just so that you could have a political sugar high was not the way that we operate in the United States of America, which believes in federalism and states' rights. And so therefore, we've had 153 years of 9 justices, 2 justices, one currently sitting and one who passed away not long ago, not only have publicly said that they are against court packing, but have basically said that 9 is a good number. Now, the bottom line is this: we need to preserve that crown jewel of independence of the judiciary. Of the 7,000 cases every year where an application for writ of certiorari, or also known as an application for permission to appeal, are filed, as General Meese will attest, only about 100 to 150 cases are rendered by the Supreme Court. That's probably less than 2%. Every one of those cases is controversial to somebody. 51% of them are either for or against that case. 49% are completely the other way. The bottom line is, though, that you want judges who are independent who wear that robe and wear it not only gracefully, but also objectively. You don't want a bunch of politicians in black robes making decisions in your cases.
This is a double-edged sword, too. For all the people on one side who are saying, I don't like this, I want to put more activist judges in there. We don't need constitutionalists. That document's outdated. It's been old. What they don't realize is a lot of these same decisions, these originalist decisions, came to their favor too, or one could say that. Let's go to United States versus Callas. That's when the police went to the fencing or the inner sanctum of somebody's home without a warrant, and that was violating his Fourth Amendment rights. There was also Sessions versus DiMaia, which protected an immigrant from being penalized according to vague laws. Originalists have saved people from abuses of the law. And that's something to consider as well. Activists will bend the law, and they've been known to do so to get, as you have all said, political means. But let's turn it around here. They could also get together and unjustly prosecute people by bending the Constitution to their own will as well.
That's certainly true. As a matter of fact, the Constitution is the greatest bulwark against having innocent people convicted, or having people convicted because of their political or religious beliefs. And we've seen where countries that don't have these kind of protections, you have the kind of thing that you see in the Marxist countries, whether it's Venezuela or Russia or wherever it might be. And so the Constitution is a protection of the innocent as well as a means of properly handling those that are guilty of crimes.
So I took an oath to defend the Constitution of the United States, and I don't believe there's any expiration date on that. And as Attorney General Meese just said, that is the foundation that maintains our system of governance. And my worry, having come through from my very early days as a young lieutenant to now working with you amazing gentlemen, is the structure that has sustained us is now being, as Attorney General Meese just said, kind of tested. And my concern is that the left trying to reinterpret and bend the Constitution to their will may eventually undermine and break it. And that's my concern at this point, because what we're seeing as a reaction to this draft decision, we don't know, but I'm pretty sure we know where it's going, will essentially encourage the left to act out violently. And to me, this circles back to the Constitution. We need to start more vigorously enforcing the laws which prohibit violence as political speech. That violence, I believe, is something that has infested our system greatly, but has often been rejected eventually. And I don't see the current administration rejecting violence as political speech. The policy of the land now, according to Jane Saki, is President Biden's okay with protesters breaking the law and going to justices' houses. I don't know how that could stand personally, but this is an example of what I'm talking about, where they're willing to bend the system when they see benefit. Although I would argue they don't think it through to the next step of what damage that will cause. And I think that's part of what we need to do as a team in 2023, 2024, with trying to make sure that politicians who are elected actually do address this as an issue, because I believe this is fundamentally a danger to the very system of governance we've accepted and has been successful for over 230 years. So
you're right, Tony. And I think it's very interesting what you mentioned about taking an oath to protect the that is, most other countries, particularly those that have a king or some other ruler, say that you commit allegiance to the king, as you do, or the queen, as you do in the United Kingdom. You gave an oath. You agreed to swear allegiance to the Constitution of the United States. And the fact that we have a constitution instead of a king is an important thing. And that's why it would be helpful, I think, if young people just learned the history of our country, the early history, and why we got to where we are now, and why the Constitution occupies such a part in our, not only in our government, but as a basis for the kind of society and the cause of freedom, which is what the earliest people who established our government were trying to do.
When I look at, I think General Meese is absolutely right that people need to learn history, but it goes farther back. The foundation of Anglo-American law is the Magna Carta, almost more than 800 years ago. And the Magna Carta stood for a very, very simple principle. The king can't make up law. Even the king is bound by law. And the problem that I see is the left believes that law should not be an impediment to whatever their particular goals are. And if you take that kind of thinking, nobody has any rights at all unless the government gives them those rights, and those rights can be taken away by the government. And in our system, rights, when politicians want to take away your rights, we have an independent Supreme Court to protect those rights. And the left's desire to destroy the Supreme Court as an independent institution is very, I think, very conscious. Very consciously, they want to destroy the protections that people have so that the government can basically take anything you have and give it to anybody they choose. And that, of course, you might note that that's one of the foundations of Marxist ideology.
Well, people should also learn when they're kids, like we used to, you're not always going to get your way. I mean, it's true. Justice Gorsuch put that into perspective in his Time magazine article. That was from, I believe it was 2019. But the fact is, the Constitution says to everybody, you're not going to get your way, but your rights will be protected as long as this union stands.
Right. Well, to that point, Chris, real quick, to add this to the discussion, as part of the research for this session today, I actually did some retrospection and review of the French Revolution and Maximilien Robespierre. Talk about what could go wrong when you decide that you're going to break the political system. Mm-hmm. It's going to come back and eat you. And I think this is what the left doesn't understand. You break our governance, it's going to come back at you. And so I would encourage young people to just study the French Revolution and just kind of go through that to see where, as Roman just talked about, these things go back. And as General Meese said, you don't want to make an allegiance to the king, and because there's a whole bunch of, we want to go back to the king. We want to go back to this. Like, I don't think you want to go back to the king. But I just encourage young folks to go look at a historic precedence where they were attempting to establish something along the lines of our Constitution, which I would argue, I don't know, I'm not an expert on French law, but I think the French Republic's better than it used to be. Just saying, I'm not there, but I'm saying, my point being, to back up Roman, is look at how, if with no framework, how the best intentions, and I would argue Maximilien Robespierre wanted the best for the French people, but the very revolution without structure came back to basically destroy him as well. So I think, yeah.
Tony, I pile on there. I would just ask anybody who thinks it's a good idea to be able to quickly change the Constitution is, do they really believe that they will always be in charge for the rest of their lives, or do they think that maybe there's a possibility that the wind will change direction, as it were, and they're going to have to go back and look at some of their changes? And you wind up in the Who song, "Meet the new boss, same as the old boss." Here, the possibility here, the probability here is that things are going to come back, as you say, going to come back around and bite them.
Yeah.
No. This is what you said is so important, Peter. I think when people look back on this era in 100 years, they will see a shift back and forth in the political system between more to the left or more to the right. But the question I think that people will be interested in is whether or not in this era we strengthened checks and balances on the abuse of power, or whether or not those checks and balances on the abuse of power were eroded. And I think we ought to be delivering a message to the elected officials we send to Washington, we ought to be asking them not just how you will use power to achieve whatever ends you have, but what will you do to either strengthen or weaken the checks and balances on the abuse of power? What will you do to preserve the independence of the Supreme Court, or will you erode it? What will you do to strengthen checks and balances against the abuse of power by the bureaucracy and by regulators? Or do you want to empower those people? What will you do to strengthen the checks on the abuse of the spending and borrowing power of Congress? Do you want to limit that, or do you want to unleash Congress further to spend and borrow beyond the country's capacity to absorb and deal with those things? And I think that question is going to be one that people will answer about this age, and we ought to be asking elected officials which side of that divide they're on.
I appreciate General Meese and General Summers and Roman and Pete joining us today. I am humbled by being part of this conversation, but I think it's so important that we try to help establish a path to public understanding, especially the young people, as we talked about, of why everything that's going on, that Roe versus Wade, the decision is simply a symptom of a larger set of issues regarding the maintaining the 9 justices, proper interpretation of original intent, and maintaining the Constitution as a fundamental foundation of our system of governance. Because this reopening of Wade is going to examine and show a lot of the threats. I hope that's the right word. A lot of the threats that a lot of us have observed regarding the left attacking the foundation of this country. So I think this is a metaphor for larger issues that we have to address. So,
Tony, I want to get to your point on that, because another thing while we prefer to discuss the Constitution and the concept of originalism versus activism at a certain level right here on Thought to Action, we can't discount the world outside the Supreme Court's chambers, one of celebrity and superficiality, one where emotions get in the way of reality. It's one where it's no longer hip or cool to defend the Constitution in the age of Twitter star politicians saying, we need things done like this. The Constitution's old. Supreme Court justices are human and subject to their own biases and political pressure. This creates this atmosphere we have now where emotionalists get bolder. And with the encouragement of this presidential administration in power, and it's been said, it's been done, we've seen it, people are encouraged to pressure Supreme Court justices into bending toward their will, even at the decision makers' own homes.
Right.
Once again, I know we touched on this a little bit earlier, but with all of that said in these times, how must we work to educate young people and budding judges with respect, adherence of, and to defend the U.S. Constitution? Again, a new generation of originalists.
I think we've already talked about the importance of understanding the history of our country. And I think the idea of the importance of stability and having some unchanging basic principles is absolutely critical to maintaining freedom. Young people always talk about being free as a very high quality. Well, I think one of the things about a freedom, the idea of if you have a valuable constitution that can be changed depending on who is in power, then you have 2 kinds of things happening at least. One is the potential for a king or a dictator, and the second is mob rule. And neither one of those is a very good way for people to live.
You know, one of the things that Keep 9 Coalition is doing to reach out to young people is we are sponsoring an essay contest with a $500 prize for the author of the best article in support of the Keep 9 Amendment to prohibit court packing, but also a $500 prize for the best article opposed to it. Because we think that the kind of informed debate about these issues is going to end up educating people in ways that alert them to the value of checks and balances. And if we can get people, even people who disagree with our position, to write about it and to think about it, that helps to frame the issue And the younger generation is the crucial determinant of the future of any society. So we're trying to get young people to think about these issues, even if they don't think about them in the same way we do, because we think that's important to the future of the country.
As a practical matter, for the last almost 2 years, I have written articles beginning with the Declaration of Independence through the Constitution for my 2 local newspapers, which are published once a week. I have received an overwhelming amount of support for those simple articles. They're written about 11th grade educational level, and I've got to go through the Constitution. As a matter of fact, tomorrow I will send an article on the 13th Amendment. That's where we are. I plan to do that. I think doing things like that from people like us is so important to educate the young people, which they apparently aren't getting the education about basic civics like we used to.
What you 3 gentlemen have just said is this idea of getting people to dig into the history and dig into, basic civics. How does the U.S. government actually work? What does the Constitution really say? And what was the birth of our country? How did this actually come about? This amazing, incredibly dramatic event that led to the creation of this country. I mean, people need to be taught that.
That's right.
To quote Cool Hand Luke, we need to get our minds right about this. And no, I'm serious. I'm a big, you guys I'm a media, I love old movies, but we need to get our minds right on this. We need to be very active in trying to establish an understanding that will help educate young people. So I'd like to maybe consider doing more of a series on this. I think we need to essentially break this down maybe and put it into some more bite-sized pieces so we can give it to folks to look at. And I'm one of those who have always appreciated gentlemen like you who don't preach to me. You simply present information for purposes for me to verify. And I know that's worked on my son, who's now 28 and a fireman and medic in Arlington. I think some of the youth are thirsty for information that will allow them to educate themselves. And I think that's a worthwhile effort for all of us to do on these issues. So.
Well, it looks like our work's cut out for us, but we will keep going with all of that. Thank you all for being with us on this edition of Thought to Action, presented by the Herb London Center for Policy Research, where we explore issues that are important to you. We'd like to thank our special guests for joining us, former U.S. Attorney General Ed Meese and the Keep 9 Coalition's Ramon Buehler, and former Tennessee Attorney General Paul Summers. Please remember to hit that like button and feel free to comment on our discussion. We appreciate your thoughts. If you haven't already, please subscribe to our Thought to Action channel and pound that big red bell for updates on future shows. Find out more about the London Center on our website, londoncenter.org. If you'd like to continue to help us create this programming, please join us on Patreon, patreon.com/Thought to Action. You'll enjoy sneak previews, special exclusive content, and our Ask Us Anything sessions. Also, you can help us greatly by sharing this video with your friends, your colleagues, and your social networks. Pick up some merch from our Thought to Action Teespring store. We have some new designs out now. We'll be adding new items soon, too. It keeps going. It's a living, breathing store. We're originalists, but we like living, breathing Teespring stores. The link to
include our 10th Amendment T-shirt. The 10th Amendment,
That's
the
right.
X is the 10th is out there. That's right. So
it's a beauty, and here it is right now. You can see it here. Get yours at our Teespring store. The link is in our video and our podcast descriptions. For our panel and the Herb London Center for Policy Research, I'm Chris Cordani. Thank you. Stay informed and make your day a great one.